Yes, good morning, everyone. My name is Robbie Burgess. I'm the head of data strategy and governance at Linklaters, which is one of the Magic Circle law firms that operates globally. So this is a challenge very much that we have to deal with, and being a law firm, we have to get it right. We're very much head above the parapet. I've spent a lot of time working in this space, and particularly around operationalizing privacy. So I guess what that means is when you're told what you need to do by perhaps your data protection officer or your in-house law team, and when that instruction gets chucked over the fence, there's then a task basically to go, okay, how are we going to do it? And that's where I've spent a lot of my efforts over the years. So I have a lot of war stories around being compliant and moving towards compliance that hopefully I can share with you today.
Thanks, Robbie. So listen, I think it's a great combination. I think, Duncan, it's great to have somebody with very deep legal experience who knows all the ins and outs of the various regulations. I think that's really useful to have at the table. And then Robbie bringing real world experience. And I know you know exactly what it's like at the front line, where things are never completely elegant, and there's always lots of rough and tumble to become compliant. So I think it's a lovely mixture of having both with us this morning. So Duncan, if you don't mind, I'll let you sort of lead off, because I know you're going to take us through a bunch of slides that take us through the various aspects of how things have changed. So I'm happy to hand over to you, Duncan.
Brilliant, thank you. Okay, so what I'm going to do is I've got some PowerPoint slides that are going to help us gain some learning and some understanding about this idea of moving personal data globally. So we know that we're right in the midst of GDPR, and in fact, not just GDPR, but changing UK legislation possibly as well. So this control of personal data isn't going to go away. And really what we need to start thinking about now is how we can get this data to flow globally between group companies or between controllers and processors. So if I were to engage with Merit, for example, to manage some data for me, how are we going to do all of that in a compliant way? How do we get to move this personal data globally and get it moving around in accordance with GDPR? So these are the three things we're going to be talking about today. Nice and straightforward is how do you move personal data across borders? So this is this idea of restricted transfers, which is sort of legal speak for something which happens almost every day in group companies, and particularly when we start using an organization to help us manage our data. So simple things like cloud, using AWS, Oracle, putting all of our cloud up on Google Cloud platforms. We're going to be moving personal data across international borders, and that's very strictly controlled by GDPR. So it's a very important part of the legislation that we need to understand. What we also have to do is do it with least commercial friction, or as Robbie was saying, that operationalization, that making it operational and making sure that what we do with our data actually is not just compliant, but it's also to the benefit of the organization. And thirdly, of course, we've got to comply with the legislation. So moving the data with least commercial friction in compliance with GDPR is quite a challenge. Those three things are actually incredibly difficult to achieve on the ground. So let's see if I can break the problem down for you. We'll go through a few slides, try to understand what we have to do as an organization that is moving the data. But I'm going to start talking to you today about the idea of exporting data and importing data, which is all part of that lovely data flow thing and your record of processing, or ROPR, that's going to be really important. So let's break the problem down. Then first thing, what data is being controlled? The second thing is to think about, what does a transfer mean? So GDPR talks about restricted transfers and the inability to transfer data across these international borders. So what is a transfer? Who has to comply? So we're all familiar with terms like controllers and processors and sub-processors, but what we really have to think about when it gets to the actual doing of this is it my job or is it your job? Who's supposed to understand the law and comply with the law? And then lastly, what actually has to be done? So once we've worked out that we are moving data that needs to be controlled, and I'm responsible for getting that control in place, I need to then ask the very important question, so what do I have to do? And as Con alluded to there, things have been moving along, and of course Brexit is one of those things that very definitely moved, and as a consequence of which we need to think about how you comply from a UK perspective and also from a European perspective. Okay, so those 4 things then, let's very quickly break those 4 problems down. The first thing is, of course, is what are we concerned about? And it's the movement of personal data. And the reason I highlight this is because businesses, particularly international groups, they share an awful lot of data globally, and not all of that data is controlled by GDPR. So a lot of business information, sales data, finance data, etc., is simply out of scope because it doesn't meet the definition of personal data. So in GDPR, it's this information that relates to identified or identifiable natural persons. We should be relatively familiar with that definition. So information that relates to people, living people, is what we're most concerned about. So obviously, marketing lists, HR data, event delegates, all of those kind of things is information which relates to a living person, and therefore that's the data flow that we need to be most concerned with, okay? So it's personal data that we're concerned with. Now, GDPR puts important restrictions on the movement of that personal data whenever it leaves your country. So if it crosses an international border, the old expression overseas, the GDPR says, I want to know all about those overseas transfer because GDPR wants to make sure that people are protected when we move the data. So what actually is a transfer? So it's important to get this thing out in your head because the world is very complicated now in terms of our digital infrastructures. There's a very obvious transfer of data that most of us will be familiar with, which is the good old Excel spreadsheet transfer, okay? So here we've got an Excel spreadsheet sitting with one entity and we move it to another entity. And here's me emailing Elfie a customer list, an Excel spreadsheet. It's got lots of customer data on it. And all I'm going to do is I'm going to attach it to an email and I'm going to send it to another organization. So that's a classic data transfer. And we can see the data has actually moved from one organization to another using an Excel spreadsheet, something that happens all the time in organizations. That is going to be controlled by the restricted transfer. The other one that is more difficult to get your head around is this concept of otherwise making the data available. So it's not that I physically sent the data. It's not that the other organization have got their hands on the spreadsheet. It's the idea of making data available. And this is something that catches a lot of people out. So here's my data center. Here's my server sitting in Europe or the UK. So I've got it nicely controlled. And I've got a bunch of people who are uploading personal data to that service. So it could be a server that we've spun up on AWS or something where we just keep data, or it could be a platform as a service like Salesforce. Somebody could have built something on Oracle or Google Cloud, but we've got the data sitting in a data center in Europe or in the UK. And then what we do is we engage with another processor or another group company, and we provide access to that entity. So there's no download of data here. It's simply giving people a login so that they can take a view on the data that's in there. And of course, that often happens where we have shared IT services across groups, or we use a data processor to help us run our database. So SQL database engineers getting access to the data, or for example, where we just decide to share the data on a shared service to allow everybody to have a single view, for example, of a customer or a data set. That is a transfer that is controlled by GDPR. So no physical movement of data, just otherwise making the data available. So when you realize that GDPR is now looking at all of these as data transfers, you'll perhaps begin to recognize that we've got quite a task to map out all of those data flows that will be controlled by GDPR. Now, having just explained what is a transfer, we have to think about when a particular data flow is not a transfer. And this is where we share data within the same legal entity, okay? So that movement of data that I've just described, the sending of an Excel spreadsheet or the allowing somebody to log in, if that is the same legal entity, then it is not a restricted transfer. So I could have some employees of my legal entity, a UK business. I could have those employees based in the US or in India or somewhere else, and they can access the data and I can send them the data free of control from this transfer rules in GDPR. But that only happens if they are the same legal entity. And one of the mistakes we often see is in group companies, they consider themselves the same legal entity because they're the same group. But what they don't realize is they need to go talk to legal or to the company secretary, because underneath that group structure are many, many different legal entities. And so a group transfer is often caught by the GDPR restricted transfer process, when in fact the guys that are working on the data don't realize it. So be careful for that particular gotcha. Okay, so we know what is being controlled, it's personal data. We know what the GDPR is looking to control, the movement or transfer of data. Now we have to ask the question, who has to comply with these GDPR rules? And that's where we get down to a slightly different nomenclature, different naming of people. So we're very familiar with the idea of calling ourselves a data controller or a data processor. What we have to recognize is that this control of the flow of data globally is also part of what we call export and import rules. So the data exporter is this legal entity that could be either a controller or a processor that instigates or kicks off this transfer of personal data from their country to an importer in another country. So if we go back to that example of the email spreadsheet that I emailed to Elfie earlier on, I could be a data controller and Elfie could be saying, hey, listen, we need to cleanse that data, that customer list. Can you send it to me, please? So that will be a controller to a processor data flow. Now, because I sent that email, I'm the exporter, okay? So the exporter is now gonna have to work hard to comply with the rules to make sure that the importer, Elfie, can work with me to protect the data that we've just transferred. Okay. Now it could work the other way around. I could be a processor and I could send it to a controller. But because I'm doing the exporting, now I need to comply with the rules. The exporter needs to think about it. And I'm actually a processor in this point. So quite confusing. So get your heads around the idea that the idea of an exporter, you can be either a controller or a processor. And as an importer, you can either be a controller or a processor. Okay. So the data exporter is subject to GDPR. They must ensure compliance. Okay, so here I am sitting in the UK. I'm subject to GDPR, and I'm just about to attach a spreadsheet to an email and send it to Elfie. Because I'm exporting from a UK entity, I'm subject to GDPR, so I've got to get my compliance ducks lined up to make sure that if I send that information to another entity in another country, I've complied with GDPR. Exporters then, so exporter may be subject to GDPR by virtue of their location of processing. So here I am in the UK, I'm established in the UK, I'm subject to UK GDPR, or a contract executed with a controller who is subject to GDPR. So we've got to watch out for those data processing agreements, those DPAs or controller to processor contracts. So there's some important legal complexity that can't be fudged. It's got to be looked at carefully to decide who has to comply with all of this stuff. Okay, so there I am. I've worked out now what data is being controlled. I've worked out what a transfer is. I now know who has to comply with GDPR. So the next question then is, okay, it's me, I'm the exporter of data, I'm subject to GDPR, what is it I've got to do to make this thing work? So this entity that instigates the transfer there, my company in the UK is exporting data over to Elfie, right? So I've got to ensure that the data remains safe wherever it goes to. So I'm going to work out with my data flow map that I've just sent an Excel spreadsheet to somebody in another country. For argument's sake, let's say it's into India. All right. So I've just sent an Excel spreadsheet to India. My job is to make sure that the data has left my hands, which was nice and safe in the UK, subject to GDPR, and it's now gone to a country that is not subject to GDPR. So effectively, I've taken the data from a safe place and put it in an unsafe place. So my job is to make sure that it remains safe throughout the life of that data. So the entity that receives the data, the importer, has got to work with me. Elfie's got to work with me because she's the importer and I'm the exporter, and we've got to continue protect all those valuable rights and freedoms that the people on that Excel spreadsheet expect from their data being processed by me in the UK. And it's GDPR that tells us how to make that compliant transfer. So I'm sitting there preparing to send the spreadsheet over to Elfie in India, and now I've got to work out what GDPR tells me to do to keep that data safe. So you can see that there's a lot of stuff that has got to happen before I even begin to work out what it is that I have to do. So I'd just like to open up to the rest of the panel now, thinking about those issues and thinking about the understanding of the data and who needs to comply and what contract are in place. I just wonder if there was any insight from the panel perhaps on that. So Con or Robbie, over to you guys.
Yeah, Robbie, do you want to go first?
Yeah, sure. So there's a couple of things there that I've noted down from what you've said there, and Duncan, from my own experience. So the first thing that you mentioned was that we need to be clear what data is actually being controlled. And there's actually a mechanism within GDPR which actually helps you do that, which is the requirement for the record of processing activities under Article 30. Now, I guess my advice here really is that don't underdo that. I think there is a massive temptation to do that in a very kind of brief way, and just to meet the letter of the law and provide just the information that it says. What I've found is that actually putting the effort in early to understand exactly what you've got and be able to use it as a launchpad for the other compliance activities that you're bound by for GDPR really puts you in a good position. And I have seen scenarios where it's been underdone, and what's being done only ticks that box, and then when they want to look at things like data transfers, they've got to go back to the beginning because they haven't really got all the information that they need. So my advice is look at that and see, does this ROPA provide you with a resource on which to manage your other privacy activities? And if it doesn't, then perhaps it needs a bit of work. So there's a really good tool there for you to use that will help you understand exactly what you've got. The point about legal structures, I think, is a really good one. As you say, you might be used to one brand, but you could have multiple legal entities sitting within that. And particularly any organisation that buys companies and an acquisitive company, you may find that one brand bought another, and although they rebranded, so from the marketing perspective, there's just one sort of face, that actually underneath is this really kind of complex web of connections between different legal entities. And the bigger the organisation, the more acquisitive it is, the more challenging that becomes. And I would suggest that you start looking at that early on in the process to understand the extent and the scope of what you've got to cope with there, basically. And any in-house legal counsel that you have should be able to help you with that. The other thing as well, in terms of understanding what data you're transferring and the process and who it's going to, is quite often a scenario where looking at a whole process, that it's not one individual or one function that knows exactly what's going on. It's not uncommon that an IT function, a technical function, won't know what data is leaving its boundaries, and it's quite common as well for the part of the business that manages the process that doesn't actually know where the technology sits. So actually, if you speak to one or the other, you may only be getting half the picture. So make sure you really understand exactly what's going on and that you document it. Documentation is really, really key to this. Another thing as well to help with any form of lineage or data flow documentation. So we use a lineage tool which helps us map the relationships and data flows between different tools. But if you're not you don't have that at your disposal, or you're not large enough perhaps to warrant something like that, actually just having kind of visual maps in Visio or even, you know, PowerPoint really do help you understand where those data flows are going. Because let's say, for example, you've got several flows that originate from different parts of your organization, but you identify that they're actually kind of flowing out to the same exporter. If you cover the principles around that, that importer, if you cover the requirements around that importer, you've covered it for all 4 of those, for example. So having that map is really, really useful. A couple of other points as well, in terms of data flows, and I've seen this happen before, where you may have an out-of-date privacy notice on your website, which says that you don't do data transfers outside of your territory or outside of the EU, and the business is always evolving and something happens and actually suddenly you're breaking what you say. And to that point, if you've collected data against an old notice which says you didn't do that, if you don't have good metadata in your systems to identify what was captured before you changed your practice and therefore changed your notice, then you aren't going to be able to tell who has consented, as it were, or has been notified that that you're now transferring to a third party and that your data is being transferred. So the ramifications of this are really kind of like bleed into your whole infrastructure, how your organization works, how your data is set up, and the different tools that you use. Those are my key points.
Yeah, I think that's very good, Robbie. I think for me, certainly the amount of collaboration people are doing across borders, I think it did accelerate in COVID and with cloud computing as well, of course. And so, yeah, it's just certainly that case about group companies and making sure, even though you're under the same brand, you see those people as colleagues that you work with every day. But if they're based in Eastern Europe or they're based in India, then you've got to look into this and make sure that your partner, you know, the business that you're dealing with kind of is tuned in as well. I'm not just blowing Merit's own trumpet here, but whoever your supplier is or whoever your partner is, make sure that they're tuned up. We find ourselves sometimes kind of advising our own customers and sometimes slowing down our own process because we can see that they just haven't really put a lot of thought into their role as the controller and the exporter. And so we've had to sort of go back to people and just get them to do a bit more housekeeping, which as a supplier sometimes can be a little bit uncomfortable, but I think it's the right thing to do. So, you know, certainly from my point of view, and we've operational bases in India where I am today, just be careful about who you're partnering with and make sure that they cooperate with you fully. So I think because there's definitely, whether you're getting software developed and databases tested and SQL written for you, or whether you're getting a company like us to embellish your data, enhance your data, or bring it up to date, just make sure that partner is really switched on. I think it's quite important. It's kind of obvious, but yeah. So, but yeah, thanks, Robbie, for those. And yeah, Duncan, happy to go back to you.
Okay, yeah, thank you. I just realized just how parallel my life is with Robbie's, just when you realize that there are columns on that record of processing spreadsheet that often get left blank. And when you come to do this job, it's the blank columns in that record of processing where people have failed to identify who owns the contract or where it is that they've just done the bare minimum of a ROPA. And actually, it does come back to haunt you later on because those are the columns that we go to and we look for the data to identify those data flows. Okay, so look, we know that this isn't going to be easy, and we know that we need to think carefully about the way that data is flowing, but let's just have a look now and try and work out what it is we've got to do in terms of our compliance then. So what does a compliant transfer actually look like? So it's complicated, so hang on. I'm going to go through it relatively quickly. Like I say, this is a complicated area of GDPR, but I'm going to try and just bring you up to speed in terms of those key areas that we need to be thinking about. So there are lots of controls that we can apply, and I'm very much praising what GDPR allows us to do here, but experience tells me that we often end up with these two particular controls. In other words, the idea that when we move the data, when we transfer it across borders, there is this condition called adequacy, which is effectively where data rules are the same. That one is very familiar to most organizations, particularly operating UK EU. And then the other one that is most common, of course, are these standard contractual clauses. So a lot of people that have dabbled or have started or are up to their necks in trying to get compliant data transfers will definitely be dealing with standard contractual clauses or SCCs. So of those two then, let's just quickly understand what adequacy means, what it's all about. So the UK and the European Union now post-Brexit have their own lists of safe countries, and these are what we call adequate countries. UK and EU currently recognize each other's list, although what we are seeing now with the new Data Protection and Digital Information Bill is a divergence, perhaps away from Europe. So this is something to watch out for operationally. But today, and for the next few years at least, we recognize each other's adequate lists. And that means that data can flow freely between the European Economic Area, Europe plus Iceland, Liechtenstein, and Switzerland, those guys. So Europe can flow freely between the EEA and the UK and what we call the 13 other currently adequate countries. And there's just a list of those for you. So if you have identified a data flow between a company in the European Economic Area and your company in the UK, or vice versa, or perhaps to Japan or Gibraltar or Switzerland or New Zealand, those will be covered under adequacy rules. Now that's nice and straightforward. Basically, in layman's speak, it means crack on. All right, so we can make those transfers. We don't need to put any other safeguards in place because those fundamental rights and freedoms, the right of privacy and the right of data protection, have been addressed by domestic law in all of those listed countries. So European, EU, UK data flows, nice and straightforward currently, nothing else we have to do. What we now have to think about though is what is a data flow, or what do we need to do if the data is to an organization that is not in one of these territories. So it's not to the European Economic Area, or it's not to one of those current 13 adequate countries. So if there is no adequacy agreement in place, for example, the example I gave earlier of sending the spreadsheet to an organization in India, if there is no adequacy, I now have to pick another safeguard. And the one that is most frequently used, perhaps about 80% of the time, are these standard contractual clauses, or SCCs. So getting your head around SCCs is going to be really important. So this is an option for us to use. These are effectively multi-party templated contracts between the exporter and the importer that I spoke about earlier. Now I'm choosing my language carefully here, so I'm avoiding words like controller and processor, because when we talk about data transfers, it's important we understand who's pushing the data and who's receiving it. So multi-party templated contract sounds good, particularly if you're a multinational group of companies spread around the world. So here's something we can all use that's a template that is accepted as being legal. So geez, why wouldn't I use these things? All right, so they're flexible. The new version that's out has a modular approach, which allows me to basically pick and choose the bits that I want, and also some mandatory clauses that I have to leave in place. So this is all sounding pretty good. If I've got that data flow, that Excel spreadsheet flowing from UK to India, this looks like something which I could probably use to make sure I've got perhaps not frictionless, but low friction compliant flow of data from the UK to India. Okay, now here's where we get into some of the murky waters. This is something we often see people getting confused. There are two versions of the European standard contractual clauses. So remember, I'm running a scenario now where I'm a UK exporter and I've got a company in India I want to send my data to. So I'm already getting confused because I'm starting to look at European standard contractual clauses, and I thought we'd left Europe. So there are still these standard contractual clauses in place, and we are still able to use them, and they are still very valuable because, of course, a lot of people are using the EU SCCs. They're being used all across Europe and indeed in the UK. So what are the two versions that I'm talking about then? The first version is what we call the C2P, controller to processor SCCs. Now these specifically address these Article 28 requirements, which most of us in common speak call data processing agreements, or DPAs. So if I've decided to use Con, and Con's going to do some data work for me, some data appending or data cleansing, I'd be a data controller. I've chosen Merit as a data processor. I know that GDPR tells me I have to have a contract in place to make sure that the data is protected when I give it to another organization. Not transfer it, just give it to this other organization. So those are what are called the C2P SCCs. So Europe has a standard set which we can use. Some complexity in there about being in the UK, but they're a templated set of documents, and they're very good for getting a very quick contract in place between a controller and a processor. Now, what we're talking about today mainly is not the C2P standard contractual clauses, but the transfer standard contractual clauses. In other words, this ability or addressing the requirement for these restricted transfers that cross international borders. So if you're Googling SCCs, just be careful when you pick them up not to pick up the wrong set. There's one for data controller processor relationships, and there's another for transferring data across borders. Now, a little bit of complexity, but also some good news is those transfer standard contractual clauses actually contain the controller to processor standard contractual clauses, but not in reverse. As you can see, the standard contractual clause for controller to processor doesn't contain the transfer requirements. What does that mean? It means that if I decide to use Merit as a data processor and there is a transfer of data across an international border, I can use the transfer SCCs to kill two birds with one stone. In other words, I just need one set of standard contractual clauses, and it covers all of my responsibilities in terms of getting a processor engaged and compliant and a transfer happening in a compliant way. So look out for that. If you're faced with a situation of having to put both, don't draft two sets of contracts if you can get away with just one set. Okay, so be aware that those two exist. Okay, now, what about this idea then that we now have to think about the difference between what if I'm a European company as opposed to what if I'm a UK company? So if you are subject to EU GDPR, so instead of being based in the UK, here's Duncan's company based in France, for example. So I know that I'm going to be subject to EU GDPR. If I want to make this transfer of data from France to India, then I've basically only got one option, and that is to use the latest version of the European Union transfer standard contractual clauses. So I'm just going to go straight onto the European Commission website. I'm going to download that templated document, and I'm going to use that as my safeguard for transferring the data or exporting the data from France to India. So nice and straightforward for the EU data exporter. They've just got one document that they use, and they will use that to control or safeguard the flow of data over to Merit in India. No other option available to me. What if I'm subject to UK GDPR though? So here I am, a company based in the UK, and I'm making that same transfer across to Merit in India. I actually have two options now. And this is where there's an enormous amount of confusion that I am going to sort out for you today. So it's all around this IDTA acronym or initialism that's out there. So there's an International Data Transfer Agreement, which is known as the IDTA, and that is available only to me as a UK organization, the IDTA. Okay, so that's something that the UK Information Commissioner has developed, and that's available to me now as a UK exporter subject to UK GDPR. But there is another option, and this is actually quite an attractive option for group companies that have entities based in Europe and in the UK and are transferring data around the rest of the world. And this is a combination of those EU transfer clauses that I just mentioned and something very confusingly called the IDT addendum, the International Data Transfer Addendum. And I regularly review contracts where these things have been transposed incorrectly. So there's an international data transfer agreement that is a standalone separate document available to UK exporters. And then there is this combination of a UK addendum plus the European transfer SCCs, and those I can use in combination to ensure that that Excel spreadsheet that is exported from the UK over to Merit in India is done so in a compliant GDPR fashion. Okay, so that first option then, using the IDTA, the International Data Transfer Agreement, it's a single agreement. It's only available to UK exporters, and it includes a very important part of a compliant data transfer, which is called a transfer risk assessment. I told you need to hang on. Okay, so there's a transfer risk assessment, which is horrendously complicated, but currently our UK regulator, the Information Commissioner, is only looking for best endeavours, which I think means they also realise it's really hard and they haven't got their heads around it yet, but they will eventually. So in order to make a compliant transfer, that Excel spreadsheet that I emailed over to Elfie, I'm going to put in place an international data transfer agreement, and I, the exporter, I'm going to work with Elfie in India, the importer, and we are going to make sure that we have filled all the boxes, ticked all the boxes, and achieved a compliant transfer. So that's the first option that is available to me as a UK exporter of data. Okay, what is that second option then? That combination of an international data transfer addendum and EU SCCs. This is also available to me as a UK exporter. So I've decided perhaps that the data transfer agreement, the IDTA, is perhaps not the most appropriate tool because I'm part of a group of companies, some of whom are based in Europe. So in order to standardize things across the group company, the UK companies have decided to use option 2, which is the IDT addendum. Okay, so the UK specific international data transfer addendum allows exporters to use this 2021 transfer in modified form. Okay, so modified form, how does it all work? The two documents come together to create a set of transfer standard contractual clauses when I'm subject to UK GDPR. Okay, so a little bit of work to do, some complexity, really important that you involve, even if you've got external or internal legal, everybody needs to be involved in this thing because we are creating a set of binding contracts between organizations. So it's important that we get the legal or the law right, the contract law, as well as the GDPR law. So there you can see the ICO, this came out in March 2022. This, as you can see very clearly, is the International Data Transfer Addendum to the EU Commission's standard contractual clauses. Okay, so a little bit complicated, but that basically is, in a nutshell, those are the options that we've got. So I thought I'd just open it back up to the panel at this point and say, rather worryingly, what perhaps problems has the panel encountered when dealing with particularly those issues about choosing the correct standard contractual clauses and all of those kind of things. So Robbie, I guess that's definitely a question for you.
Well, actually, so a more general problem that I see a lot is people trying to figure out a way that this doesn't apply to them. So they look for every scenario as to why they don't have to do this. And the problem is you actually waste a lot of time doing that. I would say this generally about anything to do with privacy law is that if you employ even one person, you are dealing with personal information. So every organization really needs to get a grip of this and embrace it as well. So it's not just about complying with the law, it's actually about your reputation as well as an organization. So just accept that this is something that you're probably subject to. So, and don't try and avoid the problem. And I suppose the next, thing I see is people organising everything apart from the legalities. first, and then right up to the last minute, and then at the last minute they decide they perhaps send whatever contract that they're about to sign, and sometimes have signed with a third party, to their in-house lawyer or their procurement team or whoever, and can say, can you just give this the once over? And that's when all the problems start. So my advice there is you need to start early with these conversations with the experts in your organization, or if they're not within your organization, that you have at your disposal. So that means, make sure that you make friends with your in-house legal team or whichever advisor that you have, basically. And to be honest, the more upfront you are with them about what you want to do, and you develop that relationship earlier, they are going to trust you, so that when you want to do something in the future, it's a great deal smoother. It's something that I've learned from my own experience working various places, is actually get these guys on side and they will trust you. And that's the same with your procurement team as well. Also, you may find that in organizations of a certain size, that they already have a kind of a bundled process for onboarding third parties. And so in our organization, we have something that we call an ISRAC, which is a Information Security Requirements Assessment Questionnaire. And that bundles all of this stuff together, so that as well as all the other things that they're looking at that sort of fall outside specifically of privacy, it bundles this up, and that they actually have a standard process for assessing third parties to get them on board as well. Because you want to go live with something tomorrow, and you send it to these guys the day before, and they say, can you just have a look at this and let me know it's fine? They're going to stop you in your tracks. If your own organization which says you can't go ahead with this in the way that you want to or when you want to. So that's what I say, don't bury your head in the sand about your need to do this, and involve the people that perhaps you might not want to because you're worried what they're going to say, but actually don't be scared of it. Just work with them, and they will appreciate that as well.
I guess it looks a bit more intimidating than it actually is.
Yeah.
I mean, if those standard contractual clauses and the addendum pieces in particular, if they're available there on websites, and you can copy those into your commercial agreement or whatever master service agreement you have, I think it probably looks worse than it is, because there is a lot of nuance that Duncan took us through, and that can be a little bit intimidating, I think. But I think you're right. I think better grapple with that and not kind of hope it doesn't apply to you. Just grapple with it, because it's maybe not as bad as people think it is, especially with the clauses being available.
Well, the other thing I've seen is third parties, organisations that say, well, we'll do what you want us to do. Actually, I would be very, very wary of that. If you're if the importer, if let's say it's a third party that that you're sending the data to, if they're like, well, we'll just do what you want, don't worry, it's fine, we're quite happy, I would be really, really nervous about that, because if they're not aware of their own obligations, then it makes you wonder what else they're not that bothered about. So, again, that's to the point, don't try and ignore it. So yeah.
Yeah, I guess, I mean, just go back, Duncan, if I can ask you about the IDT Act and then the addendum. I mean, are most people, I guess, defaulting to the combination of the addendum plus the SSEs? Is there any point in using the
Yeah, it's a little bit, the IDTA is a little bit simpler, I think. It's something which is new. The paint's still wet very much on IDTAs, the UK only version. It is a simpler document to get your head round and work through. The combination of the addendum and the SCCs can be complicated initially. The addendum, for example, asks a question like, which law is going to apply to this contract? And of course, if you're a UK only, you're thinking, well, isn't that the UK law? And so there's some complexity in there about choosing a jurisdiction, which is very much in the remit of the legal team. And as Robbie was saying, when a company that you engage with doesn't even want to know the answer to that question, it just smacks of somebody who's not really understanding the obligations they're placing themselves under by signing that document. So currently, most people were using the old European SCCs. and have simply migrated across post-Brexit to the addendum plus the European SCCs. And the good news about the European SCC model is that that modular approach is actually very accommodating. So most of the data flows that we were talking about initially today, for example, data flows that Merit would be involved in, sharing data globally, they are very much accommodated by the European SCCs. And if you're dealing with European customers, they of course will be much more familiar with them than the UK only IDTA, the International Data Transfer Agreement.
Yeah, yeah. And I guess just touching on that other point that popped up, that the best endeavors point, and I guess any regulator is going to look to see if there's an investigation that you have and your partners have best endeavors, and I guess ensuring that your partners are, I don't know, ISO certified or have been audited by the British Standards Institute, or that they can demonstrate the Cyber Essentials and all the rest of it. I guess some of that would help in showing that you're working with somebody who takes it seriously.
I think Robbie nailed it when she said documented. It's like the one thing you need, if you've ever sat down with the regulator on the other side of the table because something's gone wrong, you are desperate to be able to hand documents over to them and say, we did this, we did this, we did this. And one of those key things that you did would have been to have looked at the regime that you're sending the data to. So if I sent data to India, I need to have demonstrated that I looked at Indian privacy law and that I felt confident that the Indian government was not going to override those fundamental rights and principles. So it's incredibly complicated. How is a small company going to know what the Indian government would do in terms of their right of access to data? So this is why regulators need to step in here and help us. They haven't yet. So they've asked us to do best endeavors. Your safest thing is data minimization. Only send the minimum data you need to that territory you're not sure about. That's probably the best thing you can do as an organization, rather than trying to unravel the surveillance laws of India or wherever and work that out.
I think there's a question here as well, Duncan, if I can read from Philip. Most of the webinar seems to focus on exporters of data. Can you say something about imports? As a UK-based market research company, what needs to happen if we import personal data collected by a research partner in India? So I'll just read that a second time. Can you say something about imports, or importers probably?
Sure.
As a UK-based market research company, what needs to happen if we import personal data collected by a research partner in India?
Okay. So the first question we ask is, the company that's exporting the data coming from India, are they subject to GDPR? And in most cases, the answer will be no. It's a nuanced question. They could be subject, but they're probably not, on the basis that they are asking them to process data about, say, people not in Europe or the UK. So that data flows very freely from India to the UK. So the UK company that imports it doesn't have a lot to do until they get it. Once they've got the data, of course, they must now apply GDPR to all of that data processing. And this is where there's a bit of a subtle problem, is that they then send the data, having worked on it, they send it back to the Indian company. Well, they're a processor sending it back to a controller. And this is where this module 4 of the SCCs really starts to sing, because what it is a way of setting an agreement between the Indian company and the UK company that permits the flow of data going back to an organization. And if you look at it carefully, you probably find that you don't even need to put a control in place, because this European Standard Contractual Clause recognizes that Indian data flowing to the UK bounced back to India doesn't need a control. But if you add extra data in, so you're doing a data appending or data enrichment, and you add data about individuals in Europe or in the UK, and then return it back to the Indian company, now you need that module 4 in place. So that importer does have to think about it, because they become the exporter when they send it back to the company. And that's the subtle nuance there of how this all works. And that's why, as Robbie said, getting that lineage, that data flow, because that importer in the UK should have a line on their roper that says send data back to customer. And that, how it's done, the information security and everything, it needs to be on that roper and needs to be covered by this transfer mechanism.
Yeah, I'd be actually interested to see from our attendees. I don't know if we can, if it's too late to do the poll, Alfie, but to see how many of the attendees are using data processors overseas or offshore, just to get a straw poll. We've been told not to vote, so we don't skew the numbers. Robbie, anything else on making friends in legal and IT and any other departments that I mean, I guess marketing teams are going to be usually quite heavily involved in this space. Anything else for those guys to think about based on what
I think as I mean, the nature of marketing is that it's sometimes you have to respond very quickly to, whether it's sort of changing circumstances and so on. So you do want all of this to happen quite smoothly, if you like. So that's why I was do the work up front to create those relationships and to get your sort of templates in place, if you like, and your processes documented as well as to what you do and how you do it. Because there will be a scenario where you're asked to turn something around very, very quickly, and starting to design these processes and templates at that point, it means you'll either decide that you're going to you can't do it, or you're not going to hit the deadline, or you're not going to do it at all, basically. So that's what I would say. Just plan ahead. That would be my.
And I did like that bit where your current employer has that standard set of kind of assessment questionnaire. That sounds like it's quite useful, because it's probably something that's shared and can be sent across quite quickly. It might take your vendor quite a while to fill it up, I guess, depending how extensive it is. But even a basic version of that is probably good to have on hand. As you say, a lot of jobs have a lot of urgency, especially for new people joining the marketing teams and stuff. Having something like that available is probably quite handy.
Well, I mean, what we did actually with you guys, Merit, was we got all of that in place actually before we did our first piece of work, and I think there was a gap between having got all of that sorted before we actually put our first piece of work with you. So if you think you're probably going to be working with a supplier, there's no harm in actually getting that set up, to be perfectly honest.
Great. Alfie, I think we still have the poll window in front of us. We'll go back to the slides. Duncan, do you want to finish off?
Yeah, sure. Yeah. Yep. Obviously we've in terms of a takeaway, if you like, what we need to do finally. Hopefully the chat that's been going on, you'll have heard that this, getting prepared, pre-preparing, doing your ropers, getting your flow maps, engaging with all the stakeholders, those things I hope you've taken away from the content already. But I thought what I'd do is I'd just try and come up with a list, if you like, a list of things that would help following the sort of today, a 6-point action plan, or just things to remind you as a takeaway, what is it that you're going to need to start thinking about. So as we've been talking about a lot in the last sort of 45 minutes or hour or so, is that you need to identify these data flows. There's no way around it. It's not a compliance burden. It's actually good business practice just to understand how your business works. Don't let GDPR drive this. Make sure that you understand what the flow of data is in your organization, just from an information governance or corporate governance perspective. Know what you've got and how that data actually moves. And that's going to give you that vision of when you need to react. What is it that you need to do if you're an exporter of data? And obviously, if you've decided that there is a data flow that is crossing your international border, so it's leaving your country of establishment and going somewhere else, you need to identify that requirement to comply with GDPR. So that basic question is, where am I? Whose law am I subject to? So am I subject to UK or EU GDPR? That very much then helps you decide which version of the transfer controls you're going to use, the ITTA or the addendum plus the European standard contractual clauses. Then I'm going to work closely with my importer. So I'm going to identify the country of the entity that receives my data, the importer. And the reason I'm going to do that is because we need to work together to make sure that there is in place a transfer risk assessment that I've mentioned. So I'm having got that vision or that visibility, the helicopter view of what's going on, then I'm going to make sure that that export of data, that outward flow, has a safeguard in place, because that's what GDPR requires of me. So for each flow, I'm going to make sure a safeguard is in place. So I'm going to choose my options. If I'm a UK exporter, IDT addendum or IDTA. And if I'm an EU exporter, sorry, I'm going to put those EU SCCs in place. So helicopter view, identified all of my data flows, worked out what law I have to comply with, and then put a compliance method in place. Then I'm going to do this risk assessment that we briefly mentioned. It's an important part of the new process following some European case law, but I'm basically trying to work out, is it safe to send data to a particular country, not to a particular organization, but the country of that organization. So if I'm sending it to Merit in India, I'm starting to think about legislative processes that operate within India. So it's a very complicated process, and that's why, as I said at line item 3, work closely with your importer, because they probably have better knowledge of domestic law than I do sitting in the UK. So that risk assessment then means that I've got a defensible position. If something goes wrong, I can demonstrate to a regulator or to a court that I was accountable, that I knew what I was doing, and I tried my very best to make that flow safe. And then finally, as I think, Robbie, you were just talking about with Con there, is don't forget that you can get ahead of the process. So don't forget that you can use these transfer controls to actually form a contract with your processor. You know you're going to have to do that, and I think the ISRAC that you were talking about, Robbie, the requirement for information security questionnaire, obviously that kicks off a discussion about how we're going to contract with each other. If we're going to put transfer controls in place, could we use the European version to make sure that all of those things are there and tied up in one document? So those, I think, are the 6 things that I think probably we should be thinking about once we recognize that we've got these international data transfers.
Perfect.
Okay,
Perfect.
Thank you.
Thank you, and spot on time as well, Duncan. So that was impeccable. Well, listen, I think we're on the hour, so we'll wrap up. Huge thank you to you, Duncan, for taking us through that so assiduously and so clearly, making a complex area quite clear, I think, at the end. So that was really, really good. And Robbie, thanks for all of the guidance, the tips, the bear traps to avoid. That's been, I'm sure, very helpful. I'm sure that's sparked a couple of thoughts with the audience that they'll go off and check now, hopefully, and get sorted out. So yeah, and thank you to everybody for attending and for turning up. We did do our poll. We do have one more question. I don't know, Robbie and Duncan, if you're okay to stay on to handle one more, would that be okay? And from anybody else as well. If there is a security breach in data that has happened in India with an Indian company, being the controller, do the GDPR regulations apply? So let me just say that again. If there's a security breach in data that is, and I presume what she's saying is that the data breach has happened in India.
Yeah.
But being the controller, as a British company, do GDPR regulations apply? And I guess they do if the controller is a British company. And then I guess you're into sort of mitigating the breach. Any thoughts on? I don't know if you've dealt with breaches, Duncan. You might in your legal practice, or Robbie, what to do if there is a breach offshore with your partner company.
Yeah, there's a very obviously there's a breach process that you follow through, and as Robbie said earlier, don't create that breach process after the breach. Write it, get it practiced, and work it through, all the way down to having a statement ready for your comms team about when the breach that hasn't happened yet happens, because it will. So get all of that stuff in place. Just very quickly, Robbie, I'm sure we'll have some insight on this, but That breach question, who's responsible? Obviously, I sent the data to the importer. The exporter and importer sign a legally binding contract that binds the importer to a version of GDPR. Okay, so when a breach happens, that importer is going to have to answer to a version of GDPR, either the UK or the EU version, and that carries some particularly large fines. So that's why it's important, as you said, that that importer reads the document and understands what they're signing and signing up to.
Yeah, there's something here about the accountability principle that you recognise, if you can demonstrate that you recognise your accountability, you put in place all of the things that you were meant to do. You did everything, and there was still a breach, and this does happen. But a regulator is far more likely to look upon you favourably because you did everything you could. It's not about not being in court or not having a problem these days. It's about being set up to prevent and minimise the bad things going wrong. So be proactive.
The person that put that question in, I would recommend they read the regulator, the ICO's regulatory action policy. It really does set out what Robbie just talked about there, which is what sends the fine up and what brings the fine down. And absolutely, accountability will bring the fine down.
Great, but yeah, okay, hopefully that answers Zach's question. So we leave it at that, guys. Again, thank you so much, Robbie. Thanks a million, Duncan, for taking us through all that. Appreciate your valuable time and insight. And thank you to everybody who tuned in, and thanks for staying with us. And we'll hopefully see you at another seminar in the not too distant future. Okay, thank you, folks.